Well, good afternoon. Good afternoon and welcome to another of our Webinar Wednesdays, hosted by the CSU Bakersfield Small Business Development Center. This is episode number 79 of our Managing Your Small Business Beyond the Pandemic series that began back on March 18th of 2020. Got a great program for you today. A lot of things happening in the intellectual property world, and we'll get to that in just a little bit. But first of all, good afternoon. My name's Kelly Bearden, and I'm your host, and I'm the director of the SBDC, and we're part of America's SBDC program. Today is actually September 15th, 2021. It's Small Business Week. So U.S. National Small Business Week is occurring right now. It's an event that's usually hosted in the first week of May, but was kind of pushed back because of the pandemic. So I wanted to wish everybody a happy Small Business Week this week. So also another big topic around at least the SBDC is COVID-19 EIDL, the SBA's disaster loan program that we discussed at our very first pandemic relief webinar last year, is now on the clock, as I like to say. So I'm under the impression that even though the program runs till the end of this year, what you're looking at is this program likely ending sometime in October and maybe as soon as October 8th or 9th. So we'll talk about what we think you need to do in order to look into potentially taking advantage of some of the funds while they're still around. Our California Relief Grant program is in the final round number 9, and is open till September 30th. If you were able to access the $5,000, $15,000, or $25,000 grants through lendistry.com, then you're done. But if you've been waitlisted, if you have not heard, it's always good to go back and look at your emails to see if you have an email from Lendistry. Typically, on how a successful California Relief Grant applicant would happen would be you would receive an email from Lendistry, and it would require additional actions. You would have to provide more information to them before you were funded. If you were not funded, you were waitlisted, and right now they are reviewing those that had not been funded at this time and also looking at new applications until the end of the month, until September 30th. Looks like potentially the Delta variant form of COVID in Kern County is peaking, which is something that's grateful as we concern ourselves with less than perfect business conditions. And small businesses I've talked to are concerned about the variant and also COVID creating more havoc than we've seen over the last 18 months. You're going to get a good dose of patents, trademarks, and trade secrets today. Our ERC, our Employee Retention Credit, will have an update. Really no changes this week, but we'll cover where we stand with that particular program, which is set to expire the end of the year, but has conditions that would have it expire on September 30th if the infrastructure bill is actually passed by the House of Representatives. So your PPP forgiveness update, we'll have a little of that today. Put your questions today. Please go to the Q&A box. You'll find the Q&A box at the top. We'll have other related information that is actually put into the chat box by our producer, Maureen Busherdang. And also, a poll. We'll have a little poll coming up in a little bit. So if you're not new to this webinar, then you've seen probably this actual slide with twice as many programs on it that is on today. So where we would have 12 programs, some of them that have expired, we'll take them off, such as your PPP first draw, PPP second draw, your PUA unemployment insurance. Also, we had others with the SVOG, the Shuttered Venues Operator Grants, and the Restaurant Revitalization Program, all removed from the screen. And really the focus of what you're going to get a heavy dose of in our next couple of weeks while it's still open and while there's still opportunity is going to be with the EIDL program. The EIDL program is open. I'm throwing a new acronym at you, UFE. UFE stands for it's open until funds are expended, or until the end of the year, whichever comes first. We think funds will be expended sometime around October the 10th. You can apply for a new EIDL loan. You can apply for an increase up to $2 million. We talked last Wednesday about EIDL likely going up to $2 million maximum and the consequences that would hold. And that did happen. So we'll talk a little bit, and you're going to get a good dose of EIDL because really it could be the last pandemic relief program that's available for small businesses. And if we run into more issues with the Delta variant, or maybe, who knows, next year it's Alpha or Beta. I hope not, but who knows? If that happens, we're going to run into issues with maybe some businesses not having enough money. So we also have the employee retention credit, and it is open until 12/31. The targeted EIDL is open. The supplemental targeted advance EIDL is open. Mentioned a little bit about the California Relief Grant Program, which is really now open with round 9 through the end of this particular month. And also PPP forgiveness that we'll talk about as well. So with these managing pandemic relief, that is really what this whole series has been about. It's been about managing your particular business so you can maximize pandemic relief, keep your doors open, keep your employees employed, and keep providing great small business services and goods to your community. So all these programs could be very well be gone in just a few weeks. So it's really kind of a last call for managing these programs. And really what you need to do is really look at your individual situation. Look at the borrowing that is specific to you. Analyze your situation. We can sit here and generalize all day about what will work most for most of you. It'll work best for the majority of you here. But what you're going to find is that you have individual specifics in your business that are new and true to you. So stay with what you think is best for your particular business. We also think it's important that you understand the timelines and then also the eligible uses of funds. Many of you have received multiple pandemic relief grants, loans, other programs, and understand that those need to be used in conjunction with each other. They cannot be used the same set of expenditures or same set of funds for the same particular program. For example, if you got funds from the restaurant revitalization program, you can't use the same expenses for your PPP or vice versa. So we also want you to really kind of balance the expenditures. So along those lines for a maximum benefit, and by being able to do that, you know, you're able to maximize the entire amount of funds that Congress has appropriated and that you can utilize to keep your business going. So as we have been talking about, first of all, we talked about when EIDL has gone now to $2 million, but the cap was actually increased to $500,000 back in March of 2020. Before that, it was down to $150,000. So what we're seeing is that there are EIDL funds available, and it's an opportunity for you to either to apply for more funds, to apply for reconsideration if you've been denied. And if you've been denied, it's not uncommon. There are a lot of factors that are going on right now that were not going on last year if you received an original EIDL. And one of those things is, with the economic injury disaster loan, a lot of things last year happened rather quickly. There's a lot more fraud protection going on, a lot more going into as far as background searches before this money goes out. And if you've had any changes in your business in 19 and 20, those changes can get caught up into a denial of EIDL funds. So what makes EIDL so attractive is it has a 30-year maturity. It has an interest rate of 2.75 for nonprofits and 3 3/4 for business uses. And that is very cheap money if you have a need for that particular type of funding. So a few of the requirements that are there. One thing that I want to make sure that we're aware of is that EIDL funding was used basically for working capital and notes payable. That is what it was for. If you look at your LL&A, which is your loan agreement and authorization, you will find exactly the terms of that particular loan, how your loan is structured and collateralized. One thing, though, a lot of people don't understand is that those funds, when they were made available to borrowers, they needed to be used for specific purposes for working capital, accounts payable, and notes payable of that business. That has changed. So now what we're seeing is that a number of businesses that now can use that for either business debt or other purposes. So all of a sudden now the game has changed, which has been fairly common throughout this entire 18-month ordeal, about how things have changed, and actually now they can be used for business debt, including credit card debt of the business. It can be done for actually advance payments of other SBA debt. So really some really great opportunity here that I want to make sure everybody realizes and understands before it's gone, because everybody's got used to, available capital, but really when this is gone, who knows if there will be any more or if there will even be a need for it. Hopefully there won't be a need for it, but this is a program that started off, look at the PPP program. It started off as an 8-week program. Major League Baseball paused for 7 days, and now we're 18 months into this and we're still not resolved. There's no 100% guarantee that this is going to end before another 18 months. So I'm just wanting you to be prepared and trying to make sure you have adequate funding if necessary before October 8, when they start hitting this out to the $2 million people, which I expect will expand the program. So last week, as far as the numbers go, we did have about around 3,000 new EIDLs approved. It's still up to about 264 billion of the 367 that's available. Of that, once they hit the $2 million and they start accepting loans for $2 million, which they will on October 8th, we forecast that 53,000 businesses would expend the funds. And we do anticipate, our guess is that nationwide there will be 53,000 businesses that apply for a $2 million EIDL. And that's because there are a lot of businesses that $150,000 was a drop in the bucket. There were businesses that $500,000 didn't really meet their working capital needs, and the $2 million was really needed and warranted. And then remember also, if the House passes, it says there it is expected to pass sometime by the end of this month. I'd take the word expected out of that if I had a chance to do so right now. Who knows what's going on politically and what is happening. So what I would do is I would expect that the EIDL money is going to come out and go there if there's any available at that time. We talked about some of the, your EIDL increase or your EIDL loan. It can be used to pay off commercial debt, including credit cards and government-backed debt. Originally for working capital, notes payable, and short-term debt. I'm glad I mentioned that twice, because this was new with this new aspect of it, and you can take out some of your commercial debt that you didn't have before. Okay, so I'm going to warn you, until EIDL's gone, I am going to be talking about EIDL here every Wednesday and really go through some scenarios to where it really will work best for some people and where it doesn't. Talked about the California Relief Grant, round 9 is open, employee retention tax credit, and I know I'm blowing through this stuff very quickly today. Our last webinar, number 78, which is on our YouTube channel, our CSUB SBDC YouTube channel, it is up, and if you want to get into a lot of this information in much greater detail, we did the deep dive, full hour dive on that last week. And that information is all pretty fresh and current, except we were still speculating on the $2 million EIDL, which happened basically that day. So we have the employee retention tax credit, which is, still pertinent and still available. It's been a lot of businesses have been able to really manage their PPP to maximize their employee retention credit. We did find out and talked a little bit last week that you will need to reduce your wage expense to the equal amount of the credits. And in future years, that will probably boost your taxable income on your tax return. One thing about ERC is there's a new defined business called a recovery business. And a recovery business is one that began after February 15th. And they can now qualify for the employee retention credits if they had annual gross receipts under $1 million. So new businesses that started after February 15th, you've been precluded from getting into many of these programs, almost all of them. Here's an opportunity where if you are retaining employees and have under $1 million, you can jump into that. So lastly, let's talk about a little bit about forgiveness. And the forgiveness, the one point I really want to make on forgiveness, I was hoping to do today our question of the week on forgiveness. We'll defer that to next week. But we will actually, in talking about forgiveness, the key thing I really want to impart and have for several weeks now, or months, is that forgiveness is right now a one-shot deal. You actually put your forgiveness application in, and if it's accepted by the SBA, you're done. Now, if changes happen, or if you're not sure of all the consequences that have come out of the SBA's guidance, a lot of their final rules that have come out, you really need to make sure of all of those. And we were going to go over an example that we'll go over maybe next week on what happens when you stack a PPP1 and a PPP2 loan within the same calendar year, which would be only possible here in 2021. So there was a lot of activity about that. Can I get a PPP1? Can I get a PPP2 before PPP runs out of funds, which happened to be for most lenders on May 6th, for all of them on May 27th. So we'll go get into that in more detail. But remember, you have 24 weeks to use the funds if you elect the 24-week covered period. And you have a 10-week window from the end of that covered period. And then it's still 60 and 90 days. If you miss the 10-month window, you're fine. What's going to happen is you're going to get a bill saying that you need to start paying on your PPP loan. Now, you do need to, that is really your message to actually jump in and to take care of it if you haven't already. But these are going to be PPPs that originated last April and May, possibly moving into June now. You still will have an opportunity to get those, get that PPP loan entirely forgiven. But you will need to start making payments, and those payments are still subject to a question whether you will be able to get those back or not. But there still is the 10-month window from the covered period to apply for forgiveness will not affect the forgiveness aspect of it, only the fact that you will need to start making payments. Okay, so that's on PPP. And again, it's, this thing has changed so many times and morphed so many times that really the biggest mistake we're seeing now is people will file an incorrect version of that and it's final. So just make sure everything has been thought out, everything has been double checked, all your numbers, everything else. Once it goes to your bank, they will make a determination, which always does not benefit the small business owner. And we have seen more and more of those pop up to where the small business does not agree with their lender and what has actually been proposed for forgiveness. Your top 5 things for forgiveness, there they pretty much are. Go back last week, we'll give you 10 of them, okay? But now it's time, let's introduce our special guest for today. And Ken Takeda is a regional outreach officer for the Western Region Office of the U.S. Patent and Trademark Office, located in San Jose, California. They do a variety of outreach beyond the Silicon Valley throughout California, and their region also includes Alaska, Arizona, Hawaii, Nevada, Oregon, and Washington. Previously, Ken was a senior legislative staffer in Washington, D.C., and he holds his bachelor and actually master's of science degree in chemical engineering. That sounds very difficult to me, Ken, from Rensselaer Polytech Institute and the University of South Florida, respectively. Ken, thank you for joining us today. And what I'm going to do now that I've had a chance to introduce you, is do a quick poll question and actually stop the share to do that and launch this particular poll. It's very simple this week. It's on intellectual property, and it's what I'm most interested in learning today. Is it going to be on patents, trademarks, trade secrets, or all of the above? So our poll today is on which intellectual property am I most interested in? Is it the patent? Is it the trademark? Is it the trade secrets, or is it all of the above? So we have about half of you, 50% of you have participated so far, and getting up there. So give you another couple of moments to share what you're most interested in today. Patents, trademarks, trade secrets. Is there a thing called trade dress? For some reason that keeps coming to mind, but I'll let Ken take care of that one, or all of the above. Okay, we got 2/3 of you in. We're going to go ahead and end the poll now and share the results with you. And look at that. All of the above, 83%. 9% for trade secrets and for trademarks. So thank you for participating in today's poll. Ken, I hope that provided, that narrowed things down to all of the above. So thank you for joining us, and take it away, Ken.
Well, thank you very much, Kelly, for the introduction and the poll survey. It's very enlightening. Surprised no one chose patents. But thank you again for the CSU Bakersfield SBDC for inviting the USPTO to speak. I also want to mention that I have two of my colleagues with us, Monica Shin and Rochelle Reichert. They will be occasionally answering questions. So if you see their name pop up, they're just with USPTO, and they're actually patent examiners that are temporarily on loan or detail to help with our outreach duties. And they normally do give presentations on different subject matter as well. So I'd like to start off. Let me share my screen first. That would be great. There we go. So at this point, you should see just the title screen. And we don't have a lot of time, and you probably can guess that most of this material is could be very dense. So what I really want to focus on are the 4 basic versions of intellectual property, give you kind of an overview of them, and then also really highlight USPTO resources available to you. And again, we have, as the agency, we have a number of programs, webinar series focused on different parts of intellectual property. So we can definitely point you to those webinars as well, and they're all free and open to the public. Just a disclaimer clause, we are unable to provide any legal or specific business guidance, but please take this as a possible resource for presentation, as a presentation. Now, just to describe USPTO briefly, we are the United States Patent and Trademark Office. So as the name entails, we grant US patents and register US trademarks. There are other forms of intellectual property that we also help the administration by giving guidance on them, but we do not necessarily work directly with that. So specifically copyrights. The US Copyright Office is actually the office that registers copyrights. We are roughly 13,000 employees as of end of last fiscal year. As you can see, we receive about 653,000 patent applications a year, and roughly the same, almost the same number of trademark applications. We are a completely user fee funded agency, so we do not use any taxpayer money. But with that said, because of all of the user fees from these patent and trademark applications, we still are roughly a $3.7 billion agency annually. That's the amount of fees we generally collect. And as you can see at the very bottom, our headquarters is primarily in Alexandria, Virginia, where most of our staff are. Of course, it's closed right now, but we also have 4 regional offices. I work out of the San Jose office, and then Rochelle and Monica are supporting our Denver office. Just briefly, intellectual property is deeply rooted in our US history. It's actually in the Constitution, as you can see here, Article 1, Section 8, Clause 8. This clause, Congress shall have power to promote progress of science and useful arts. Basically, it's talking about patents and copyrights there. Trademarks is actually rooted in the Commerce Clause of the Constitution. Now, what exactly is intellectual property? Well, it's property, it's an asset. It could have value. So just like real estate, such as your home, or even a vehicle that you may own, you could also own intellectual property. Now, generally, intellectual property is a creation of the mind, however. So think of literary and artistic works, inventions, symbols, things of that nature, something that's used mostly in commerce, so it might have value. That's why it's so important for you as a small business owner or an entrepreneur to consider it in part of your strategy. Now, we're not advocating that you need to have patents or trademarks, but it's a consideration that you should have. So some of the benefits, again, it could attract investors and buyers. If you ever see Shark Tank, that's a classic example of a show that there are investors looking and or receiving pitches from small businesses or growing businesses, and they often ask, well, do you have a patent or a patent application? Well, that's why. These are assets to consider. Some intellectual property could be used for deterring infringement. Could leverage. It's a property right that can add value, and it give you a global presence. And I want to be clear on this point, just because intellectual property in the United States and every other country, they're all territorial. What I mean by that is there's no such thing as, say, a worldwide patent. Each country that has a patent system has its own patent laws. Similarly, trademarks, copyrights, and even trade secrets and other forms of intellectual property. So if you get a patent in the United States from the USPTO, our agency, then it's good to help protect your invention or patent, enforce your invention within the United States and its territories only. So that's why we're saying it's territorial. So if you wanted to get protection in, say, China or Germany, you would actually have to apply for a patent in those countries as well. However, US patents and trademarks could help you to receive those protections in those other countries. So some of the things you really need to consider is assess your company's IP assets and prioritize. And we'll quickly go over the 4 major intellectual property forms. Know your competition. What's the pace of innovation, opportunities for growth? So basically think about some of these will allow you to basically have a short time monopoly. So that's what a patent does. And how do you protect your IP? So that's another part that you really should consider is even once you get a patent or a trademark or a copyright, do you plan on enforcing it? What if someone starts using your invention, starts using your trademark? Do you have the resources to actually enforce that? And then develop plans, get help. And hopefully we'll explain to you a lot of different ways to get help. Sorry if I'm going a little fast. I do have a few slides to go through, so hopefully it won't be, we'll have some question and answer time at the end. So these are the 4 major types of intellectual property. The patents you're probably somewhat familiar with. It's a new inventive idea, non-obvious. That this is one of the intellectual properties that we deal with directly. And there's different forms of patents as well, and I'll explain that a little bit later. Trademarks, so those identify origins of goods and services. You'll usually recognize it with the R symbol, R circle symbol, or the TM or SM symbols. Copyrights, creative expressions, and trade secrets. And when you're considering your own company's IP, and if you want to protect them, you should also think about if you have a product or even a process, there may be multiple forms of intellectual property involved in that product or process. Just as an example here, we have a typical iPhone, but within it, you can identify multiple areas and multiple intellectual property that's being used on this iPhone. So just for example, trademarks. Well, obviously the name Apple, iPhone, the utility patents, design patents, trade secrets, copyrights. So design patents is interesting because if you recall recently, Samsung and Apple had quite the legal dispute against each other that went all the way to the Supreme Court just a few years ago. I believe at the end, Apple was awarded about $539 million in infringement costs. So let's quickly go over each type. So trade secrets. Basically, trade secrets is information used in business that gives an opportunity to obtain an economic advantage over competitors who do not know or use it. So for example, maybe a formula or recipe in this case. So KFC, what's the secret blend of spices and herbs on the KFC recipe? Patterns, compilations, programs. Google, what's the secret algorithm, search algorithm that they use? So these are some forms of trade secrets, and it's interesting to note that you don't register a trade secret with any agency, because if you did that, then you would basically be disclosing it. It's actually up to the company to make basically some protection around their trade secrets to police themselves. So you don't want to allow any employee access to your trade secrets, and trade secrets could be something simple as like your client list. And because of that, most trade secrets are protected by labor laws and employment agreements, workplace agreements. And just recently, there's federal statute called the Defend Trade Secret Act that basically made it possible to sue in federal court if there was a trade secret misappropriated. And many of these cases are where one employee takes a trade secret from a company, leaves a company, and joins another company and discloses that trade secret from the previous employer. So that's why a lot of it is wrapped around labor laws and non-compete clauses, things of that nature. So I just kind of already went through this, but One thing to stress here is that the company needs to make reasonable efforts to preserve the confidentiality of your trade secrets. You can't just like leave it unlocked somewhere or unprotected or send it email all the time, things like that. You really need to, in order to make a case that something is a trade secret to you, because remember, you don't register it with any agency. It's basically up to you to keep it secret. You will really want to make an effort to make it secret and confidential. So one of the benefits of having a trade secret, of course, is if you can make it confidential and secret, then you can basically hold on to it for forever. Think about Coca-Cola's secret formula, right? Or even the KFC Google search algorithms, things of that nature. Now, it's much harder to do something like that if it's a mechanical device or an invention, because someone could legally just reverse engineer your mechanical device and learn your secrets, learn the secret within that. So that's why some people would be more inclined to use a patent on that if it's a new invention. Copyrights. So you probably recognize a C circle. That's again, this is the US Copyright Office that registers copyrights. And there's many forms of copyrights, literary works, music works, dramatic, pictorial, motion pictures, sound. All of these are potentially copyrightable. One thing that you really want to focus on, though, is it needs to be fixed on a tangible form. So one example I like to give on this is so if you choreograph a dance, now just the choreography of it isn't copyrightable until you put it on a piece of paper or record it somehow, just like in music. If you're just playing it, it's not copyrightable. But if you put it on music sheets or record it somewhere, then it is. So that's where the clause here applies, fixed in a tangible form. And there's multiple term lengths of a copyright, but for the most part, it's the author's life plus 7 years after their death. If it's owned by a company, it has a slightly different terms and things of that nature. So that's something you really want to check with the US Copyright Office before, if you really want to determine the term of your copyright. Now, also, I'd like to mention, so you don't need to register with the Copyright Office. You automatically have certain rights just when you create something yourself, something that's new. So original work of authorship is key there. Now, if you want to have some bearing in federal court, then that's when you really want to have US copyright, a registered copyright at the Copyright Office. That way you can actually use federal court to go for infringement. Some of the other things that are great about registering, or benefits of registering, is you could record your copyrights with the US Customs and Border Protection, CBP, to help prevent importation of products that might be infringing on your copyright. And trademarks. So you might recognize the TM or the R circle, and there's also an SM or service mark. But trademarks, you're probably very familiar with this. It's the most popular form of intellectual property. You don't need to have a new invention. You don't have to need like some artistic expression, but most companies have a name. Most companies have a slogan. Those potentially could be trademarked. So basically, it's any word, symbol, design, or combination that identifies a source of goods or service. So what I mean by service is basically, say you're an accounting firm or a general contractor, construction contractor. You're actually providing a service, not actually a good in that case, right? If you're an accounting firm, you're providing your accounting services. But trademarks still apply in that case. And just to highlight the potential value of a trademark, and this is some data provided by Interbrand, which is basically a private company that performs brand valuations. But in one of their more recent evaluations, they show some of the top global brands. And this is only their branding. Apple, you expect Apple to be up here, but they're valuing Apple's brand to be $322 billion just on the branding. None of their capital, none of their, their production or their products, manufacturing, anything, just their branding. And it really speaks to the power of a trademark. You see, you probably recognize every single one of these companies, right? And you probably already know exactly what they manufacture or primarily manufacture. If I were to say Toyota, you immediately think vehicles, right? If I say Samsung, you probably think mobile phones or computers or electronic devices immediately. That's the power of a trademark, where it identifies the source of goods and services. And also, it also helps the consumer if you think about it. What if you were to see a Mercedes-Benz, brand new Mercedes-Benz with all the bells and whistles, and then you see another vehicle that has the exact same bells and whistles at the same price, but you've never heard of the name of the company? Who are you more likely to select to purchase? Something that you're more familiar with. A manufacturer that has maybe a better reputation, or so you would probably select Mercedes-Benz if everything's comparable, right? So that's why it also helps the consumer identify where their products are coming from. And similar to copyrights, you actually have common law trademarks. So basically, once you start using your company name somewhere, you basically have some common law rights to that name. Now they tend to be limited and very specific to a region. So if you're, say, in Bakersfield and you open up, this is probably a bad example, but Joe's Laundromat, well, that's a pretty generic name, but you might have some very limited trademark rights just in that Bakersfield area. And there's actually state registrations of trademarks as well. So you could register with your state, your trademark, and get some protections within your state. But if you want to get federal protections, so basically all over the country, then you really should consider registering with the US Patent and Trademark Office, because then you have protection across the country. You could also bring legal action in federal court against infringers. You can use the registration symbol, R symbol. That's always an option. You don't have to use R symbol, but it's basically provides the public notice that you're willing to protect your trademark because you've registered it. And similarly to copyrights, you could also register your trademark with US Customs and Border Protection. Just quickly, you'll all recognize these examples of trademarks: Starbucks, Nike, Target. Symbols. Here, Starbucks is actually using the TM trademark. So even as a common law trademark, you still can use TM or SM, service mark, but you could only use the R circle if you have a US federally registered trademark. But you immediately recognize these symbols. And just to add, it doesn't need to be a word or a diagram or even a slogan. Some trademarks are actually sounds, like the Pillsbury Doughboy laugh or NBC chimes, things of that nature. Some of them could be colors, scents, smells. And for an example of colors, on the left, you probably immediately recognize what company that represents, that the robin egg blue color. That's Tiffany box. And then whenever you see one of these coming down the street, well, you recognize it's brown. It's UPS, United Parcel Service. And they actually did quite an effort. They had quite an effort to associate the brown, color brown, to delivery services to represent UPS. If you remember a few years ago, they had this whole advertisement scheme about what can brown do for you. And that helped establish their company as brown trademark as a color. And of course, the green and yellow color scheme of John Deere, you easily recognize. One few things to point out though, a domain name is not a trademark registration. A trade name is not a trademark registration. So even if you were able to register your company on GoDaddy.com and got your URL address, that's not a trademark registration. And also, if you were able to get your company incorporated in Delaware or California or somewhere, that doesn't necessarily mean you have a trademark registration. You still have to apply for those. And then we have patents. This is by far the biggest part of our agency. We have the most patent examiners, and Monica and Rochelle could definitely attest to that. And it's quite complicated to get a patent. I'm not going to sugarcoat it. And for the most part, we do recommend that anyone that's thinking of getting a patent, they should really engage with an attorney, an IP attorney or a patent attorney or agent, because it is quite involved. But we do have resources that that we could point out at the end of this presentation to help give you some guidance on that. But again, so patents are basically, again, a property right to exclude others from making, using, offering, blah, blah, blah. So the main thing I want to say here is to exclude others. It's an interesting term because it doesn't actually say that you have the right to create your own invention. Because many times, even if we go back to our mobile phone example, many times there's going to be a number of patents within an invention. Say your patent, or what you want to get patent, your invention is an improvement upon this mobile phone. It doesn't, if you get the patent granted, it doesn't give you the right to actually manufacture that mobile phone, because that's not really your invention that you protect. You're protecting with the patent. But the mobile phone may be necessary for your invention to actually work. So keep that in mind. It's an interesting distinction, but many people fail to see that it's to exclude others from your invention. And then it's basically a quid pro quo system, something for something. So you receive a limited monopoly of roughly 20 years if it's a utility patent in exchange for public disclosure. So basically what that means is you can have this exclusion right where for about 20 years, but at the end of that time, your invention, and because you stated how to enable your invention within the patent application and then granted patent, your invention goes to the public domain for others to improve upon it. And we do have three main types of patents. Most people will think of the utility patent, such as the mobile phone, so new and useful, machine, article of manufacture, composition of matter, things of that nature. Then there's lesser known design patents and plant patents. And design patents are interesting. They're basically protecting the ornamental feature of something. So again, I kind of mentioned this before, back describing the Apple versus Samsung patent infringement disputes. Many of those disputes were about their design patents and how the shape of their corners of their mobile phones were protected by design patents, or their home button was protected by design patents. In this case, it looks like the creator of the Statue of Liberty actually had a design patent originally. And then there's plant patents. Very few people use plant patents, but they're basically patents to protect asexually reproduced plant varieties. So think of maybe a new form of tulip with specific color and things of that nature. So lots of exotic flowers and things of that nature will fall in that plant patent category. I already kind of mentioned this, and we're running out of time, so I just want to quickly go over and, one thing I do really want to stress, risk of disclosure. Because patents have, in order to get a patent, your invention needs to be new. Then that also includes if you accidentally or purposely disclose your invention before you even submit an application. That's disclosure, public disclosure. Say you're at a trade show and you have a booth and you're trying to encourage investors, and you're basically letting the cat out of the bag and describing to them how your invention works and what the novel approach is and everything. You're basically disclosing your invention to the public at that point. Now, in the United States, you have basically a 1-year grace period from when you make that disclosure, first disclosure, to submitting a patent application. But however, if you are intending to protect yourself in other countries, many other countries don't have that 1-year grace period. So just be careful of that. And this also relates to crowdfunding campaigns. So think of Kickstarter campaigns. If you're promising to sell, that also could be considered risk of disclosure or public disclosure. I don't think it's fully been gone through the legal recourse of that, because it's fairly new process, but I would be very concerned about that if you were promising on a crowd-funded campaign to sell your investors or contributors your invention. Some things that we have in place at the USPTO that you should be aware of. So as a small business, generally you would be qualified to be a small entity, and that provides 50% discount on all our patent fees. And there's actually also a micro entity status, which qualifies someone to have 75% discount on our patent fees. And you can see what are those qualifications are on our website. But these are just kind of quick highlights. Let's go to resources because we're really running out of time. One of the easiest places to go to for further resources that I would like to highlight is on our website. We have a section for startups, and it gives you quite a number of different resources and services that are targeted for small businesses, but anyone basically could use for the most part. One of them is an interesting test or assessment where it's an IP awareness assessment where it'll ask you a series of questions and it'll give you some guidance on what resources you should look into. We have patent and trademark resource centers. They're basically a nationwide network of public libraries. As you can see here, we have a number in California. They all have some training in patent and trademark information, some products as well that we provide. We also have a patent pro bono program, which we collaborate with basically nonprofit attorney organizations that provide pro bono services to under-resourced inventors and small businesses. In the state of California, we work with the California Lawyers for the Arts. They have a program specifically called California Inventor Assistance Program, CIAP, and you can go to them to see what their eligibility requirements are. We also have law school clinic program where we work with different law schools that provide assistance from their law students under the guidance of faculty. So for California, we have a number of law schools locally in California, but if you go to the website, you can see all the law schools that serve multiple areas. So many of these schools don't just serve the Central Valley or California, they might serve nationally, and vice versa. Some of these other schools might serve nationally. We also have help centers, the Inventor Assistance Center, basically for patents assistance. It's from our headquarters on the East Coast, and this is the number 1-800-786-9199. And it's actually the same number for our Trademark Assistance Center, but they'll direct you if you have a specific patent or trademark question to which center. So, and then again, we have some more resources. And I mentioned this before, but we have quite a number of webinars, virtual webinars, free, open to the public. If you just go to our main events page, you can see what's coming up next. We have I think it's a 9-part Path to a Patent series. The next one coming up is tomorrow, Common Mistakes. And the series is offered every quarter. So it'll be restarting again in October. And then we also have a Trademarks Basics Bootcamp. That's also, I think, 9-part series. They're almost done with this quarter, but they'll be restarting in October as well. I apologize for going a little bit over. I try to go as fast as I could, but it's quite a bit of information. If we have a little bit more time, I think we could try to answer some questions.
Ah, fantastic, Ken. And you know, as efficient as Monica and Rochelle are, they answered most of them when they were opened up.
Wonderful.
I did receive a couple of questions that they couldn't answer because they were emailed to me. So the first one was having to do is, what is the difference between actually receiving a patent and receiving a patent pending?
So patent pending is something that you would do if you already submitted a patent application. So you're welcome to use the patent pending kind of symbol or notice on your product or whatever if you've already submitted a patent application. We don't really govern that. It's just a notice. Now, once you receive a patent, then of course you can just state patent. And some people would actually put their patent number on it, on their products or maybe their website. And it actually could be useful because if you list your patents, someone, an investor or someone else that might be wanting to use your technology could always contact you to maybe license your technology to them for a period. And that's, again, another asset for your business.
Okay, next question was somebody else with no interest in our business is using our small business name and logo and have trademarked it. Do we have any recourse against these people?
I'm trying to think. Well, if it's trademarked within the USPTO, then they already have, basically it's first to use in that system, but first to register for our US registration system. I mean, you still can use your own name and whatever is being trademarked, but you have to be careful of your location, because again, if you've been using it, you have some common law trademark rights within your geographic area. Now, you could always run into issues. They still could go after you for infringing, especially if you become interstate commerce. In which case, that's when basically federal trademarks really take most effect. But if you just plan on using it within, say, Fresno area, then you might not have too much to worry about. But it can be a concern, definitely. But you do have some common law rights for being the first to use.
Okay, those were my questions. Well, here's an interesting one. It's my understanding that non-compete clauses are illegal in California. Is that correct? And include trade secrets. Anybody want to touch that?
I'm not fully aware, and I wouldn't be able to give you any.
Well, the non-compete clause typically happens in like the sale of a business where an owner will not compete and probably doesn't have any direct application to intellectual property. It's just a covenant between two people, one who is paying for those assets in that business, not to compete against them. So I don't really see the application to intellectual property. Do you, Ken?
Well, I think in the kind of the situation where if that you just mentioned, if the previous owner has certain like client lists or specific processes that were considered trade secrets previously, obviously they wouldn't want competition if that owner or previous owner went and sold that information to another competitor. So I think that's the application I'm thinking of. Maybe it's not as realistic or common, but.
If I could jump in real quick, I think one thing that would happen, like let's say you worked at Apple and you signed a non-compete clause, and you went to go work at Samsung, you could go work at Samsung, just pretend the non-compete clause isn't an issue, but you can't go take that information and those practices you learned at Apple and use them at Samsung. Like you can't steal Apple's trade secrets and use them at Samsung.
Very good. Very good, looking at it from that aspect. And that probably had something to do with that lawsuit between the two. Or could have. I designed something for a barbecue and need engineering that can help. I don't think I fully understand the question. I designed something for a barbecue. Well, that's good. We always need new barbecue inventions.
Definitely could appreciate that.
Yeah, definitely. And need an engineer. So I can't, I don't know. So I see one of our participants is raising their hand. let's see if there's any other questions here. Go to the chat, see if anything's happening there. Doesn't look like it.
I also like to mention we do have a series of Spanish language programs that'll start being offered in October. So October 6th is our Intro to IP, and those will soon be on our website. I don't think they are currently, but just for your awareness.
Great. Well, I think we're done. Thanks so much, Ken, Monica, and Rochelle. It's great having you on. Some great information, a lot of resources, and a lot of resources out there that a lot of people I don't think realized. And so, for Ken, I'm Kelly Bearden. Have a great week. We'll be back next week with number 80. Until then, see you then. Bye-bye, everybody.